Hello everyone and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today might be the day I earn that subscription. For today's story, we are trying to deal with more stuff from the Amber Heard Johnny Depp fallout in the continuing case of their appeal. This is the case of Amber Heard versus Johnny Depp, namely Johnny Depp's opposition to Amici curiae filing briefs in the appellate court. Amici curiae are non-parties. They are friends of the court. They would like to offer their words as disinterested parties to the case, but interested parties to the law, right? That is their role, to assist the court in development of the law. They're not really super concerned with who wins the case as such. They're concerned with the law. Now, the law, of course, will necessarily impact one party or another, but this is their primary devotion, the law first and then whatever results. Well, Depp thinks maybe less so with some of this stuff. He thinks that maybe this is not all it purports to be, and also that they haven't followed the rules, and also just being really, really sloppy and all kinds of crap. So we're just going to read this brief opposition and discuss all the things that are going on here. So let's go ahead and do that, if it will be so kind as to pop up on screen. Give me one moment, please. Maybe if I remove the window and I add it back in, maybe then it will work. I'm a professional. That's what they tell me. Let's see. Window capture, add source, window, Amici. There we go. That's not what I want to do at all. No. I'll figure this out. And the window immediately goes away. And I begin to hate my life a little bit, and the depression sinks in even more. Great. Okay. Okay. We are in the Court of Appeals in the case of Amber Heard versus Johnny Depp. I had this all set up, ready to go in advance. The appellee, Johnny Depp, by and through undersigned counsel, respectfully submits his omnibus opposition to the motion to leave to file brief for the Amici curiae by a whole bunch of people who'd like to say that they, just really care about the purity of the law and would like to make sure that the law is upheld. And that's really their primary goal in life, is to uphold the law and make sure the law is developed. All right, so here is the reasons that he opposes these amici and their participation. This is a kitchen sink appeal, with the appellate purporting to assess no fewer than 16 assignments of error. Yeah, 16 is a lot. 16 is a lot of assignments of error. That is a lot of things. That is not a great sign for an appeal. When you have to say there are 16 problems, did the trial court really screw up 16 things? Probably not, right? So this is just bad from a pure issue of tactics. Now, I wonder if this will work. Oh, good. It's still there when I come back. Thank God. So this is just a bad issue from an issue of tactics, because the trial courts are not idiots, especially Judge A, who is the chief judge of the circuit. She got chief judge of the circuit by, being around a while and being a good judge. Is she a perfect judge? Of course not, because there's no such thing as a perfect judge. Did she make mistakes? Well, maybe. She certainly did things that I wouldn't have done in her position. That doesn't necessarily mean that they're a legal mistake, because there are issues of style, and literally issues of judgment, right? That's why we have judges, for judging. And so some of her judgment does not accord to some of my judgment. Does that mean that she's in the legal wrong? No, it doesn't, because again, trial judges are afforded a fair amount of discretion. So whether or not I would have done the same thing in her position is not the right standard for the Court of Appeals. The right standard for the Court of Appeals is basically, did you screw it up so much that no judge would do this, right? Not would I have done it. Would no judge have done this, right? Would no jury have done this? This is a error. This is a systematic error. Now, did Judge A do something wrong that no judge or no jury would do? Maybe, because again, she's human, although she's been around a while, so perhaps not. But the idea that you can find something that might have some legitimacy to it is not that much a problem. The idea that you can find 16 things that she did wrong, that the Court of Appeals needs to whack her around all over the place, for the chief judge of the circuit, probably not. So are there issues in there that might be interesting? Yes. And different lawyers might have different assessments about what those would be. Like for me, for Amber Heard's appeal, I think her best issues are the error 5 dealing with the admission of the psychiatrist notes. I think there's some interesting issues under Virginia law, despite the fact that you might have hearsay problems, but perhaps not so much, because perhaps we don't have that issue because they're not being offered for the truth of the matter asserted within a legal sense. So there's something there that maybe Judge A should have admitted those things, for example. Or maybe Judge A should have offered that jury instruction dealing with having to find the subjective intent or subjective knowledge of the defamatory meaning, that Amber Heard knew the defamatory intent, which maybe they did, and maybe there's evidence about that, but maybe the jury wasn't provided that instruction. So in her 16 assignments of error, I did find something. I found 2 things. I'm like, okay, maybe there's something here. Now, different lawyers would assess this differently. And that doesn't necessarily mean that they're wrong either, because there is literally judgment calls. What is good? What is bad? What is workable? What is unworkable? And even the issues I find to be kind of a little bit workable are not great. They're not like singing the praises of, oh my God, we need to fix this. But yeah, but when you're trying to do, okay, there's 16 of them. No, there's not. There's just not. It's a bad look. You've got to figure out what your issues are, what your issues really are, and narrow this down. So trying to do 16 of these things, it's a bad look, because the good, such to the extent it exists, doesn't tend to make the bad better. It's kind of the opposite way around, right? The rotten apple makes all the other apples rotten. The good apple in the barrel of rotten apples doesn't make the rotten apples less rotten. That tends to not be how this works. It's not how human beings work, right? They see things that are toxic and they think all the things are toxic. And so many of these things are toxic. Again, the Court of Appeals to focus on any of them, even ones that might be good. It's a bad strategy. I as an appellate lawyer would probably not be bringing 16 assignments of error. It's like if I've got 3, that are really good, then okay. So there's problems there. Okay. So Amber Heard, who is represented by 2 large and well-regarded firms, maybe less so now, is seeking to array. Am I aware of another stream going for this? I hate my life, Secret McSquirrel. That's what's going on. I hate my life, and I hate everything that's happening, and I hate people, and I hate technology, and I hate life. And that's not even really a joke. The depression was real, and I was trying to do something to make myself feel better. God damn it. I can do this. Okay. Amber Heard, who's represented by two large and well-regarded firms, is seeking to relitigate virtually every major ruling made by two distinguished law firms. To relitigate virtually every major ruling made by two distinguished and highly respected chief judges of Fairfax County, Honorable White, who's retired, and Honorable Judge Penny, over the course of a 3-year litigation, 6-week trial. She probably didn't screw up everything. She probably didn't screw up everything. In addition to the oversized 55 pages that Ms. Heard has filed in support of her appeal, Amicus seeks to present a collective 93 pages of additional argument in support of Heard. One of those Amicus is just total PR and shit. The one on the First Amendment issues is at least kind of mildly interesting. It doesn't work, but at least it's kind of interesting, sort of. But yeah, if the motions were granted, Depp would be required to respond to a total of 148 pages with his own brief. Yeah, no. Though there are doubtless cases in which briefing by amici curiae might assist the court in resolving the issue, this is not one of them. Yeah. Depp respectfully submits that the filing of such extensive additional briefing by amici here is neither necessary nor appropriate and should not be allowed. As a threshold matter, the court should deny the motions because amici failed to comply with the applicable rules by, among other things, neglecting to properly assign error, where am I streaming right now? And even neglecting to properly assign error, which violation constitutes sufficient grounds for denial. Moreover, Heard is very competently represented and is not in need of assistance or additional briefing in support of her position. Nor should Depp be burned with having to respond to such voluminous additional briefing, particularly because it's crap. Facebook and YouTube? Well, at least got Facebook going for us. Twitch was the one that was breaking today, by the way. And every time I tried to start a stream, it's like, oh, Twitch is not working. But it just created a new stream every time in YouTube. Finally, the amici's arguments add nothing to legal analysis provided by appellant Heard's counsel and appear focused instead on arguing with the jury's clear findings in favor of Depp on the underlying issues. The amici proceeds from the essential premise that Heard is a representative of domestic abuse victims, a premise that was emphatically and soundly rejected by the jury, who paid careful attention to the evidence presented during a 6-week trial. Both amici briefs cherry-pick evidence they believe should have swayed the jury to a different finding, yeah, particularly that one that had all the names on it, really was just trying to fight the facts. It was really blatantly just PR. It was a bad amici brief. The other one, although it doesn't work, at least was trying to argue some legal points. They're bad law, but at least they were doing what they were supposed to do, right? Arguing the law. Like, their arguments don't work, but at least they were doing their job. The other amici was just arguing facts and being like, oh, there's a lot of facts. Both amici briefs cherry-pick evidence they believe should sway the jury, but offer the court no insight on legal issues actually issue. One of them is that's definitely true. Allowing this additional briefing would merely serve to complicate what is already a sprawling, misplaced appeal. Accordingly, Depp most respectfully requests the court deny the motions. The amici fails to comply with the applicable rules. To wit, A brief of an amici curiae must comply with the rules applicable to the brief of a party. Because the amici are supporting Miss Heard, they are required to comply with all the requirements that Heard does, including the requirement of Rule 5A20C. The brief must contain a separate heading for assignments of error. They didn't read the rules, right? That's like the canary in the coal mine. I was making this analogy yesterday with Popcorn Planet and Andy. I was making this issue. It's like that old sort of canard, I think it was Van Halen, who as part of their rider of their contracts said in their green room that there must be a bowl of only brown M&Ms. And they talked about this at one point, and they said the reason for the rider was not because they cared about the brown M&Ms. The reason for the rider was that if the brown M&Ms weren't there, it was a canary, because it's a small detail, right? It's a small detail in an overall contract, right? So if that detail isn't paid attention to, it suggests that other details are not being paid attention to. So it's caution to go look at other things, like the rigging for the stage, things that actually matter, like double check the rigging, double check things, because it shows that they don't have attention to detail, right? So this is sort of the issue. Like if you don't do that, then it suggests that you are not paying attention. So if the font isn't right, if the paper isn't right, if these things are not in the brief, it's a huge red flag to the court, because it suggests at best incompetence and at worst deliberate, that you're trying to avoid it for like word count reasons, or you're trying to avoid it for illegitimate reasons, right? It suggests either you're incompetent or nefarious. In either way, it's not a good look. So yes. So it was no brown M&Ms. Whatever, you understood the point. Either way. So the brief must contain an assignment of errors with a list of specific errors claimed to have been made by the trial court and an exact reference to pages of the record where the error was preserved. Which for some of the things that Amber Heard have, they didn't do. A failure to assign error or insufficiency in assignments of error are both bases to dismiss appeal, or in this case, dismiss the amici brief. Here, because neither party offered by the amici complies with the requirements, they do not contain a section for assignments at all, while the other one includes a separate section for assignment of error, but failed to support it with any citations to the record. Thus, it should deny motion for leave. Yeah, that's not a bad thing. So yeah, if you're not paying attention, it's not like these details are secret. All right, the rules are published, available to everybody. They're not like secret rules. Just anyone can go read them. Go read them. Just follow the thing, you know. But they didn't, which suggests problems. Subject to exceptions not here, a brief of an amici curiae is permitted only on motion and with consent of the court. The rules therefore reflect that such briefing is generally considered unnecessary. That's the rule of this appellate court, incidentally. Incidentally, the U.S. Supreme Court just changed its rule on amicis like yesterday. I don't think it goes into effect until next year. But as of like yesterday, or effective as of next year, amici at the United States Supreme Court no longer have to get permission from the parties. So, just incidentally, a rule changed. So, hey, now you know. It's undisputed that Heard is well represented by two major law firms who also acted as Heard's coach lead trial counsel. On behalf of Heard, they have already filed an oversized brief and seeks to put at issue 16 assignments of error. That is not a positive sign. And the one you let off with seem like, again, you normally like to put your brief sort of in order of best to worst. Normally, you want to lead strong. And the one they led with was inconvenient forum, which Larry from DUI Guy pointed out to me yesterday. Yes, there is case law that allows for this under some circumstances, but not here. Not here. And to lead with this issue seems like a bad choice. There were other better choices, it seems to me, to lead with. But all right. You know. She certainly does not need 93 pages of additional briefing from these amici, who also apparently used a smaller font size. So they're actually longer. Yeah, that's the kind of thing that the Court of Appeals might actually care about. That's the kind of thing that I know it might sound silly, but that is maybe the thing they might care about the most, is that you didn't take the time to actually just comply with the bottom line rules. You know, it's sloppy, it's bad, it's like it shows lack of attention to detail. The wrong font size. You missed this mandatory portion of the thing, right? You messed with the margins, you messed with the color size, you mess with these things, right? These are the kind of thing that might actually irritate the Court of Appeals more than anything else, because it shows lack of attention and lack of care and lack of respect, to be quite honest. Now, those rules might be a little bit silly or not, but they're the rules. So, yeah. Moreover, Heard's counsel appears to be acting in coordination with counsel for Amici. That's a no-no, which strongly indicates an attempt by Heard to circumvent the page limits. That's a no-no. For example, in the proposed Amici, which was filed and served the same day as the brief, Miss Heard's entire statement of facts is simply incorporated by reference. Yeah, it's not... Yeah. Mr. Depp, who had received leave to file a brief of only 55 pages, would be unnecessarily burned if the amici were allowed. Depp must also respond to Heard's highly unusual 16 separate assignments of error in a single brief. Well, most of them are garbage, so that shouldn't be too hard. Dismissing them out of hand is, you know, garbage in, garbage out, so it shouldn't be too bad. Yeah, Depp must also address 3 additional assignments of error he identified for the court's consideration in the event of remand. If the amici were allowed, Depp would be forced to respond to additional 93 pages of argument. It's unjust. I feel that. Thank you, by the way, for all your guys' support as I deal with technical issues and try to get everything streaming properly. I appreciate all of it. Depp will not address the substance of amici's arguments in detail, lol, other than to point out the arguments in their brief are for the most irrelevant to legal issues on this appeal, and consist largely of disagreement and factual findings or complaint about the impact. In the one brief, that's for sure as hell true. In the other brief, a little less true. But the one brief is just the jury is a bunch of idiots. They even said the jury is a bunch of idiots. They almost used those exact words, which is not really what you want to go to the Court of Appeals with. The amici cherry pick and misstate evidence. They maintain support to their personal factual conclusions to argue the jury got the issues wrong, lol, while ignoring substantial evidence, including testimony of credible, disinterested witnesses that was present to the trier of fact. The amici also expend many pages arguing the jury's verdict is somehow harmful to abuse victims in general, which has very little to do with anything. Such arguments are wholly inappropriate on appeal. Yeah. Did it still say Dwarf Fortress? Okay. Swing low, sweet chariot. Okay. I'm not going to let it get it to me. What's wrong and how do I fix it? Such arguments are wholly inappropriate on appeal. This court should not substitute its own judgment, much less the judgment of amici curiae, for that of the jury. Likewise, the amici's focus on some perceived social harm that will result to abuse victims generally from the verdict is both factually misguided because the jury's clearly and emphatically concluded that Depp is not an abuser, and inappropriate argument because the jury was tasked with making factual determinations with respect only to the parties in this action. Thank you for the notification I'm live. That's great, Google. An inappropriate requirement because the jury is tasked with making requirements with respect only to parties in this action, not with sending a message to society at large. In this context, it would be unfair to force Depp to use some of his limited pages in response to this extraneous argument. Moreover, a back and forth between Depp and Amici on these non-issues would be a distraction and add nothing useful. I mean, yeah, basically, I'm on board with all that, so that's perfectly fine. So yeah, I think largely for the technical reasons. The Court of Appeals will probably deny it because it's just so sloppy and a lack of attention to detail. And, you know, although of course I wouldn't put it past them to put it on the record and then just ignore it, which is some sense easier. So maybe they'll grant leave and then just ignore it. Granting leave to file it doesn't mean anything with respect to their consideration of it, right? So at the moment we're fighting about, can you even file the thing? Which at this point I'm a little bit like, no. But yeah, Glow T gives $19.99 to say you're the best, we all love you. Thank you. I appreciate it. So yeah. I'm sorry the alerts aren't going on stream because I tried to recreate the entire OBS streaming thing to fix issues, and now I just created new problems. So all right. So I guess that will bring us to the end of the stream for all of its glory that we have. Unless there's something else. Don't worry, it's all fine. Dude. Thanks, Marmite, but you know. Can they hint to JD's team that they'll be ignored as they grant leave? I mean, they won't say anything publicly about it. They're not going to grant things, but yeah. Yeah. All right. I guess I'll sign off and I'll continue fighting with various streaming tools to just be able to stream like a normal person. But at least the video and audio is working. So I got that going for me. And at least we're streaming on YouTube and Facebook. So I got that working for me. So that's something. So yeah. I got a few super chats early on. Let me take a look at the list. I don't want to... I don't see any. December 9th. A Capitan says, I feel like we need a Fleetwood Mac in the background. Tell me lies, tell me sweet little lies. Goes to Recon gave $19.99 to say, I really appreciate your analysis and low-key humor. It makes dry legal proceedings bearable and interesting for those of us who want to learn more about it. Cynic in Chief gave $2 to say subscribe. Who else can have 4 streams at once? And Glow T said, Kurt, you're the best. We all love you. And Alpha Photographer gives $10 to say, great stream as usual. Thank you very much. You should talk with Aussie. He added a soundboard this morning and spent 2 hours trying to unmute himself. That's funny. Well, I'm going to try to motivate myself to go to the gym and do something for myself today. And then maybe take a shower and see if that helps. And then at some point, I need to do some more recording and stuff because we got a lot to do. And I haven't been recording very much in the last couple days. All right, so I'm going to take some deep breaths. If you've been enjoying this content and my existential crisis, please remember to hit the like button. Don't forget you can hit the join button for 99 cents, and you too can become an uncivilian to support the channel. I've been uncivil